Section 4. Idem Arguments for the prisoners were made with great ability by Noy, Selden, and other eminent lawyers. These arguments were based on Magna Carta, above referred to, and embraced the principle alluded to in that memorable instrument. This principle, says Hallam, having been frequently transgressed by the King's Privy Council in earlier times, statutes had been repeatedly enacted, independently of the general confirmations of the Charter, to redress this material grievance. Thus, in the Statute of 25 Edward III, it is provided, that no one shall be taken by petition or suggestion to the King or his Council, unless it be, i.e., but only, by indictment or presentment, or by writ original at the common law. And this is again enacted 3 years afterward, with little variation, and once again in the course of the same reign. It was never understood, whatever the loose language of these old statutes might suggest, that a man could be kept in custody upon a criminal charge before indictment, which would have afforded too great security to offenders, but it was the regular practice that every warrant of commitment, and every return by a gaoler to the writ of habeas corpus, must express the nature of the charge, so that it might appear whether it were no legal offence, in which case the party must be instantly set at liberty, or one for which bail ought to be taken, or one for which he must be remanded to prison. It appears, also, to have been admitted without controversy, though not perhaps according to the strict letter of law, that the Privy Council might commit to prison on a criminal charge, since it seemed preposterous to deny that power to those entrusted with the care of the Commonwealth, which every petty magistrate enjoyed. But it was contended that they were as much bound as every petty magistrate to assign such a cause for their commitments as might enable the Court of King's Bench to determine whether it should release or remand the prisoner brought before them by habeas corpus. The advocates for this principle alleged several precedents, from the reign of Henry VII (1485 to 1509), to that of James, 1603 to 1625, where persons committed by the council generally, or even by the special command of the king, had been admitted to bail on their habeas corpus. But I conceive, said one of these, that our case will not stand upon precedent, but upon the fundamental laws and statutes of this realm, and though precedents look one way or the other, they are to be brought back unto the laws by which the kingdom is governed. He was aware that a pretext might be found to elude most of his precedents. Their warrant had commonly declared the party to be charged on suspicion of treason or of felony, in which case he would, of course, be bailed by the court, yet in some of these instances the words "by the king's special command" were inserted in the commitment, so that they served to repel the pretension of an arbitrary right to supersede the law by his personal authority. Ample proof was brought from the old law books that the king's command could not excuse an illegal act. "If the king command me," said one of the judges under Henry VI (1422 to 1461), "to arrest a man, and I arrest him, he shall have an action of false imprisonment against me, though it were done in the king's presence. The king," said Chief Justice Markham to Edward IV (1461 to 1483), "cannot arrest a man upon suspicion of felony or treason, as any of his subjects may, because if he should wrong a man by such arrest, he can have no remedy against him. No verbal order of the king, nor any under his sign manual or privy signet, was a command, it was contended by Selden, which the law would recognize as sufficient to arrest or detain any of his subjects, a writ duly issued under the seal of a court being the only language in which he could signify his will." They urged further, that even if the first commitment by the king's command were lawful, yet when a party had continued in prison for a reasonable time he should be brought to answer, and not be indefinitely detained, liberty being a thing so favoured by the law that it will not suffer any man to remain in confinement for any longer time than of necessity it must.